Legal learning. So today I'm going to give a discussion about the preamble of the Constitution of India. This is from AJS Mains oriented, now any judicial service Mains oriented. So it is, first of all, you need to, this is important for MCQ 1 marks. The preamble is derived from the USA, Constitution of USA. So first of all, source of the Constitution. Source of the Constitution is, in the case Union of India versus Madal Gopal Kabra, it was held that we the people of India are the sources of the Constitution. So first of all, we have to read the preamble, because if we can write the preamble as it is in the exam, there are likelihood that you can get more marks. Okay, so let's read it. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Now here we have to remember, first of all, first sovereignty comes, then socialism, and lastly secularism, SSS, and that means S3. And socialist is included here by 42nd Amendment. Secularism is included by 42nd Amendment. And to secure to all its citizens, there are certain goals, certain objectives of the preamble. Okay, justice, liberty, equality, and fraternity. These are the objectives of the preamble. Justice, that is of three kinds. SEP, that is SEP, that is social, economic, and political. Liberty of thought, expression, belief, faith, and worship. Liberty of thought is given under Article 19(1)(a) of the Constitution of India, liberty of thought and expression. Belief is given under Article 25 to 28 of the Constitution of India. Faith is also given, belief, faith, and worship, BFW. So TEBFW, okay, TEBFW. This is the mnemonic, tab FW. So SEP, tab FW. Then equality of status and of opportunity. This is also given under the PSP as well. Status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and unity and integrity of the nation. Integrity is inserted by 42nd Amendment Act 1876. Done. So this is the date of adoption. In our Constituent Assembly, this 26th day of November 1949. It was adopted in 26 November 1949. It came into force in 26 January 1950. Hereby adopt, enact, and to give a gift to ourselves. Adopt, enact, as well as give to ourselves. AEG. Egg. Adopt, enact, and give to ourselves this Constitution. So there are some cases which are important. K.M. Munshi, horoscope of the Constitution. So what is the, in this case, K.M. Munshi, it was held that according to, sorry, no, not cases, but according to K.M. Munshi, it was held that the preamble is the horoscope of the Constitution. According to Thakur Das Bhargava, it is the soul of the Constitution. And in the words of N.A. Palkiwala, it is the identity card of the Constitution. That these are what these persons respectively stated about the preamble to the Constitution of India. Okay, you can refer these people in the exam. Then first of all, we need to understand what is preamble. So a preamble is a kind of introductory statement. It is a kind of introductory statement. A statement that is introductory in its nature, and it is contained in a document, and it expresses the philosophy and the objective. So in Constitution, it represents the intention of the framers. What was the intention of the framers of the Constitution of India? Those persons who framed it. What kind of structure you wanted to have in the Constitution, like whether it is a socialist, secular, democratic republic. It is a republic, it is a democracy. Democracy because there is election is there. Universal adult franchise are there according to Article 326. And it is republic because there is no hereditary monarch. And also sovereign, the country is free from all external and internal aggression. External aggression and internal disturbance. The country is free and sovereign. The country represents secularity. That means it respects all religion. The secularity of Indian Constitution, secularism of Indian Constitution is different from the Constitution of France and USA. So then comes and socialist, which implies that it has a mixed economic structure. Mixed economy, that means there are both private and public enterprises. So then intention, then the history behind its creation. So we know there's a historical struggle behind the Constitution, behind this creation, as we know. Then core values. What are our values? Like we value justice, we value liberty, we value equality and fraternity. So these are the things, our values. And principles of the nation. So what kind of principles we want to have. So this is all about the preamble. Then comes idea and objects. So first of all, it's the source of the constitution. The source of the constitution, we the people of India. The constitution, the MLA MPs, prime ministers and all those kind of people are just representative of our state. The state belongs to us, and we have given ourselves this constitution. That's why we the people of India in the beginning of the preamble is very important. This implies the source of the constitution of India. Then comes nature of Indian state. So these are words that shows the nature of Indian state. Then comes the statement of its objectives. So these are its objectives. Then comes the date of its adoption. So this one is the date of its adoption. Then components of the preamble, we know, I have already said. Sources of authority in the constitution lies with the people of India, declares India to be a sovereign, socialist, secular, democratic republic, objective, justice, liberty, equality, fraternity and unity and integrity, and adopted in 26 November 1949. So these are the keywords. Then here for the second amendment, social equality, caste, creed. Economic equality is of two kinds, social and economic. Caste, creed, there is no division. There's reservation of course, but everyone is equal as per Article 14 of the Constitution of India. And distribution of wealth. Economic equality is distribution of wealth. Ultimate sovereignty is the people, we the people implies. Then sovereign, supreme independence, both external and internal. So socialist, mixed economy, public and private coexist. Then secular, as we Article 25 to 28. Then democratic, free and fair election is the gist of democracy. And universal adult franchise as per Article 326. Then the head of the state is elected by the people. There is direct election in legislative assembly, parliament, house of the people, and also state legislature. This is, and these are certain explanation, like sources of the constitution is the people of India. It was held in Union of India versus Madan Gopal Kabra. Madan Gopal Kabra. So you have to remember, you have to make mnemonics so that you remember the case laws, because these case laws are very important. Then sovereign, as I have already mentioned, external and internal both. The definition is given here. External sovereignty is sovereignty in international law, independent of states from one another. For example, India is no longer a dominion of England. It is no longer under any other country. Internal is that it is the right of a nation to be free from internal forces of disruptions to its rights and freedoms, to exercise the internal government of its society or territory. Then socialist, which is inserted for the second. Social economy, which is everyone is equal irrespective of caste, color, creed, sex, religion or language. This is given under Article 15, Article 16 of the Constitution of India. Economic equality, distribution of wealth by the government to provide a decent standard of living for all. This is provided under DPSP as well. Democratic socialism is what? Excel Word versus Union of India 1979 case. The SC found that with the addition of word socialist, a portal is open to learn the adjustments in favor of nationalization and state ownership of the industry. But the principle of sovereign, principle of socialism and social justice cannot ignore the interest and rights of a different section of society, private owners. So there's coexistence of both private and public enterprises or ownership. So this was held in Excel versus Union of India. What was the previous case? The previous case was Union of India versus Madan Gopal Kabra. What was held? It was the sources of the constitution is the people of India. Then another case, Excel versus Union of India 1979. Then another case, Minerva Mills versus Union of India 1980. The constitution bench had considered the meaning of the word socialist to crystallize a socialistic state securing to its people socio-economic justice by interplay of fundamental rights and DPSP. So it's Minerva Mills it was held that fundamental rights and DPSP both are important, both are needed, interplay. Play between both fundamental rights are negative obligations in the state, DPSP positive obligation of the state. Fundamental rights non-justiciable, justiciable, DPSP non-justiciable. So now here socio-economic justice. So interplay of both will lead to socio-economic justice, and socio-economic justice is what called socialism. Then comes the socialistic pattern of the country. So D.S. Nakara versus Union of India 1983 stated that socialism aims at providing the working people decent standard of living. So you can basically remember one keyword, that is decent standard of living, and that's enough. And you have to remember the case only, D.S. Nakara versus Union of India. If you write one statement, that's enough. Then secularism for the second amendment, it was inserted. The word secular implied equality of all religion and religious to tolerance. So it's called religious tolerance. It is very important. Each state has no official state religion. There are two countries in the world like Pakistan and Israel which has state religion. These two countries are based on religion. So except the other countries there are certain countries which follows the model of secularism. France like USA, India. So then comes the government must not favor or discriminate against any religion. So this is important. Then comes every person. This is Article 25. Every person has the right to practice, preach, practice, propagate any religion they choose. Then another case again SR Bombay versus Union of India. How many cases we have read? The first one was I guess Excelsior versus Union of India. The first one was Union of India versus Madan Gopal Kabra. Second one is Excelsior versus Union of India. Third, Minerva Mills versus Union of India. Then DS Nakara versus Union of India. And this one is SR Bommai versus Union of India. 1994 held that the secularism is a part of basic structure of the constitution. This is very important. Then ST Xavier College versus State of Gujarat and another. The court said secularism is neither anti-God nor pro-God. So it has a very neutral position. Neither anti nor pro, but it's neutral. Secularism means elimination of God from matters of state, and the state has nothing to do with the religion of the people. That's all. Then democracy is what? People of India elect their governments through free, fair and periodic elections. 5 years term is there. Election is free and fair. Article 324 deals with provisions relating to election. 226 universal adult franchise. Religion is election is both union, state and local level. Union level parliament. There is election in the lower house, that is House of the People or Lok Sabha. In state there might be two legislature, bicameral legislature. In some state there are unicameral legislature. So there are legislative assembly in which they are held direct election. Then local panchayat and municipalities. A system of universal adult franchise popularly known as one man one vote. Done. So then comes republic. A democratic republic is an entity in which the head of the state is elected directly or indirectly for a fixed tenure. Either direct election or indirect election. For example, the election of the President of India, that is it is indirect election. So it is called proportional representation by means of single transferable vote. So the election may be direct or indirect. Then comes justice, social justice, abolition of inequalities from society. Social justice is what Article 14 says about. Economic justice, equal wages for equal work. There's case Ranjit Singh versus Union of India. In this case, there was held that equal pay for both men and women. So equal pay for equal work. Ranjit Singh versus Union of India. This case also you can quote. Then political justice, elimination of unreasonable distinction in the political matters of the state. So this is all about preamble of the Constitution of India. So okay, another thing is very important is preamble part of the Constitution of India. In this case, there are two cases. One is Keshavananda Bharti and another is case. In this case, it was held that preamble is a key to open the mind of the framers, and if there is any ambiguity in the provisions of the Constitution, then the preamble can be restored to and interpreted for the purpose of interpreting the other provisions of the Constitution of India. But preamble is not a part of the Constitution of India. Okay, so but in the case of Keshavananda Bharti versus Union of India, it was held that preamble is part of the Constitution of India. It is integral. Another case is there SR Bommai versus Union of India. Leading case in this regard is Keshavananda Bharti's case. Okay, not SR Bommai. So it was held that you can write these key points. Integral part of Constitution of India indicates basic structure can be amended by Parliament under Article 368, but the power of amendment is limited. It cannot alter the basic structure. This is what called basic structure doctrine. So neither a social source nor a source of power nor a source of limitation prohibition, so neither justifiable nor enforceable in a court of law. So this is the nature of the preamble as it was held in SR Bommai versus Union of India. Then comes basic structure doctrine. According to Article 13 and Article 368, Article 13, any pre-constitutional law or post-constitutional law which is inconsistent or in derogation of rights conferred under Part 3 of Constitution of India is void. So Article 3, there are certain doctrines are also there. Doctrines of eclipse, doctrine of severability. These doctrines are also important. Article 13. 368, it was held that power of Parliament to amend Constitution is limited, because it cannot amend the basic structure of the Constitution of India. So this is all about the preamble of the Constitution of India. If you like this video, please do not forget to share or subscribe. And thanks for watching. Subscribe to Legal Learning.